Is a handwritten will valid in Minnesota? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today let's look at a pretty common question I get, especially when we have people who weren't working with an attorney at the time and wrote out their wishes and want that to be treated as their last will and testament. So as I said in the intro, this commonly comes up when somebody has worked at home and created their own will, usually handwriting it out on a legal pad or some other piece of paper because they just don't have the time to go to a lawyer or they don't think they want to spend the money. It can be a variety of reasons why, but at the end of the day, if we're going to look at a handwritten will, we need to understand what are the requirements to make it valid. So just like any will that you would get from a professional attorney, the first thing is the will has to be in writing. So your handwritten will that you've written on your legal pad at home can be counted as a writing if it's written in your own handwriting. Second, we need to look at whether it's signed. Once again, this is very important. We can have all kinds of notes around our house, ideas of what we want to have done with our estate after we're gone. But in the case of a will, we want it to be a formal document. We want it to be in writing and we want it to be signed. And under Minnesota law, number 3 is we need to have 2 witnesses. And this is often where I see things break down on these handwritten wills. So someone has prepared a writing at home. They've made it look like a will as best they can. Maybe they downloaded it from a website for $39.95, wherever it may have come from. So it's written out, it's signed, but they didn't get 2 witnesses. And that's one of the key hurdles we run into when we go to probate court is we have this writing, it looks like a will, but we have no witnesses. We don't know that this was actually the will that this person intended. When you work with a professional, what we usually do as part of the signing ceremony, we actually ask the person before they sign, are you over the age of 18? Have you read this will? Do you declare it to be your last will and testament? And then we have it sign it. And what they've done is they've said to the witnesses that this is my will, I'm of age, and I intend to sign this document. The question I get from clients is, let's say I've done this handwritten will at home, is it going to be valid in Minnesota? The simple answer is if you follow those 3 requirements, that it's in writing, it's signed, and it's got 2 witnesses, then it can be found to be valid by a Minnesota probate court. Now, an exception to the rule where we have a handwritten will, sometimes called a holographic will, can be where we have a handwritten will that's treated as valid under another state where it was made. And in this situation, what we need to do is ask the probate court to validate it under the idea of reciprocity, meaning that Minnesota will honor the rules of a different state that allows for a handwritten will. And so if it's valid in that state where it was written, we ask the court it to be valid here in Minnesota as well. Now, if you're thinking about doing a handwritten will instead of working with a professional, there's 4 main risks that I want you to look out for. Number 1, the lack of witnesses. As I said, this is the biggest mistake I see with people trying to do a will on their own, is they don't have witnesses to when they sign it. Second, we look for ambiguity in what's written. So first of all, if you're going to handwrite it, we have to be able to read your handwriting. So if you have a big legal pad and you've written out 8 pages that you want to be your will, but nobody can actually read it, we may have to find a handwriting expert to try to decipher what you've written. Writing it yourself, you may use terms that you don't mean to use. You may have downloaded the wrong template. And so there may be some ambiguity in what you're actually trying to do with your estate plan. The third risk, there's a real potential for fraud. If it's handwritten, do we know it's your handwriting? Is it somebody else's? Do we know if it's your signature? Again, that's why we use the witnesses. So we have 2 people who saw you sign it at that time who could then testify to a court. Yes, I saw John Smith sign this document, this piece of paper on December 1st, 2023. So we know that it would be the valid will that he was trying to create. And number 4, outdated information. What happens a lot of time is people who are writing a handwritten will are under some time constraint or they're worried about something. And so they just write things out quickly. And that may be just what's affecting them at that moment. But those wishes may change over time. And if so, we want to update that estate plan to encompass what you really want your legacy to look like. So maybe you're not under the stress of that upcoming medical procedure. And now you want to change some things around, maybe have somebody else be your personal representative. So we've seen what we can do as far as a handwritten will and whether or not it's going to be valid. So let's look at 4 steps that we can do to make sure we are creating that valid will in Minnesota. Number 1, I recommend that you consult with an attorney. Obviously, I'm an attorney. Estate planning professionals, we prefer to work with you to make sure not only that you're drafting the right document, but that you're getting the right document for your legacy. So a lot of times I meet with clients who have signed a will that they downloaded from a website, and we find that it's not really saying what they thought it was going to say. So they've spent $39.95 or $99, whatever it is. Sometimes it's for a different state where they don't live, because all those document production companies do is just take your information, mail merge it into a template, send it off to you, and leave it on you to figure out the signing. That's why working with a professional can make sure that we get the right document for you, signed in the right way. Step 2, use proper witnesses. Again, when you're working with a professional, they'll normally have witnesses in their office and a notary public, so that all you have to do is show up. The documents are pre-printed, ready to go. It's a much faster signing ceremony than you trying to run around and sort out witnesses and notary publics and everything else. Number 3, store it in a safe place. Please, not in a safe deposit box. And if you're not sure why, you can go to my YouTube channel and find the videos on why you don't want to store your will in a safe deposit box. The short of it is, a safe deposit box gets locked down after you die. So if your will is in there, then we're forced to go to court to get a court order to open the safe deposit box. And step 4, let's make sure we keep your documents up to date. If you have life changes, new children, new grandchildren, somebody died, maybe there's been a divorce in the family, we want to make sure our documents are consistently reviewed and updated to reflect your actual wishes for your legacy. So hopefully this has been a helpful primer for you looking at handwritten wills in Minnesota. As I said, they have to be in writing, signed, and with 2 proper witnesses. So you can do them, but there can be a lot of risk by doing this. So we suggest you work with a professional. If you have more questions, you can go to my website, 𝙁𝙊𝙍𝙀𝙍. There's a red legal strategy session button on the front page. Click that and you'll be taken to my calendar, where we can set up a 15 or 20-minute phone call to talk about your estate plan, your ideas for your legacy, and how we can put the right documents in place for you. If you like this video, you can hit the like or thumbs up button below. You can always subscribe for more episodes on YouTube. And if you have any questions about handwritten wills in Minnesota, remember, it's not something I suggest you try. There's lots of little pitfalls, but we want to make sure that we're getting the right document for you and your legacy.